everyone is here. We understand that our ex officio student board member is very busily involved in an extracurricular activity, which is volleyball.
We won. It was very intense, and you probably need to get it.
And with that, we're going to move to item number 3. And I pledge allegiance to the flag of the United States of America,
and to the republic which stands one nation under God, indivisible, with liberty and justice for all.
with that, we move to the order of the board. Does any board member have something they'd like to share this morning? Happy New Year.
Rex for science and math.
Yes. Fantastic job. Excellent. Staying on. Try again. With that, we'll move to the opportunity for the public to be heard. If anyone in the public would like to come forward to the podium, address the board, now is the opportunity. All right, with that, we invite our council, the council for the district. Ryan Malay is here to present to us. It's basically an opportunity for the board to learn more about student discipline. There is a slideshow that goes along with this. This slideshow will be posted along with the agenda.
Lonnie, could you please turn on the screen? Thank you.
And this works, if you hear me? I apologize, the audience. I'm going to try not to have my back to you. Back to some of these folks here. So thank you for having me. I was invited to talk tonight about student discipline as a component of professional development for you as the board. I appreciate it. I don't often have that opportunity, so I always like when the client's interested in the law. You can't hear me? Okay. So tonight we're talking about student discipline. I'd like to give you kind of the 30,000-foot view because there's a lot of minutiae and intricacies of this aspect of the law, but I think that having a conversation tonight is going to be a good jumping off point. If you could advance the slides, please. One more time, please. So before we get into what the law provides and what role the board plays and your administration plays, I think it's important to take a moment to talk about the current state of student discipline in New York State. And I start the conversation with referencing SED's Safe Schools Task Force. So obviously SED is the State Education Department in Albany. They started in 2019, I believe, gathered together a task force of stakeholders to look at what steps the state can take to make schools safer, but also to consider reforming school discipline. They issued a report in December of 2022, which came up with some recommendations, some observations. These columns here, this language is taken directly from the report, and it talks about exclusionary discipline. When we talk about student discipline, more often than not, we're thinking of exclusionary discipline. That's not just a suspension from school, it could be exclusion from a classroom as well. What's important for school district purposes is, this comes from SED, it talks about the harmful effects, according to SED, of removing students from their education. There have been studies that talk about the lingering effects of exclusion, all the way to diminished graduation rates. And if you look at the second column, it talks about U.S. Departments of Health and Human Services and the Department of Education. They deem that it's consistent with their missions to prevent, limit, and eventually eliminate exclusionary discipline practices. So historically, when I was in school and when my parents were in school, suspensions were very common. They weren't thought of twice. Corporal punishment was a thing when my parents were in school. You'll see here, though, that for the first time in the last 10 years now, there's been a real focus on not just limiting, but doing away with exclusionary and disciplinary consequences. That is a new consideration. This is, again, a 2022 report, but that is something that you as a board need to be aware of. I do believe that the trend going forward in New York State will be further limitations on a school district's ability to impose these types of disciplinary consequences on students. So that is something to be cognizant of. You can advance for me, please. And then we see around this same period of time a decision of the Commissioner of Education in 2021. The facts aren't particularly relevant. I include this because the Commissioner took this opportunity to speak to the same types of considerations that were set forth in that report that came out a year later. If you look at the underlined language, I added the underlining, the Commissioner didn't do that. But the idea is that suspension should not be punitive. These disciplinary consequences under the education law that your code of conduct speak to is not a punitive measure. It's a corrective measure. It should be a restorative measure, but it should not be punitive. You as a board, if you look in the left-hand column, second paragraph, as is a federal law that we're all subject to as a public school, there is specific language that speaks to limiting and being cognizant of the overuse of disciplinary practices to remove students from the classroom. You as a board that reviews your code of conduct every year, generally in the summer months, the expectation is that you're looking at the data, considering the information that's coming across the superintendent's desk, and making sure that your code of conduct are taking those steps to limit the overuse of exclusion. In the second column, we talk about, and ESSA talks about, and the Commissioner expects, that you'll incorporate progressive model of student discipline, that they be age appropriate, and you'll hear talk about restorative practices. Restorative practices are the direction that the state wants public schools to lean into heavily, to take the place of these exclusionary practices. Some of our challenges in public schools is that when you have situations that result in disciplinary proceedings, right now under the education law, your superintendent's options are limited, and they don't allow for the unilateral implementation of things that you might feel would be in the best interest of the child. You can't unilaterally impose a requirement for counseling or drug counseling, or whatever the case may be that the superintendent may feel is most important in this particular situation. Right now, under the education law, if we're at the point where we're at a superintendent's hearing, which we're going to talk about, the options are exclude or not exclude. So the law does need some tweaking, in my opinion, to allow for more opportunities for the imposition of these types of restorative practices. Right now, we're relying upon cooperation from families, and not every family is open to that idea. But this is the decision of the Commissioner. I think it captures where she is and where the Education Department is quite well, even in 2025. And I do see us moving further down that road in the future. Any questions about that? Yeah, please. So there's different procedural safeguards for in-school suspensions. It does fall under that umbrella of an exclusionary consequence, though. So we're going to talk about the due process. Students have many rights, which is appropriate, which makes sense, but there are many rights that students have before consequences, suspensions can be imposed. But under the umbrella of exclusion would be removal from a classroom to go to the principal's office, removal from the classroom to go into an ISS or an in-school suspension room, and then what maybe most folks would think about, which is removal of a student from the school grounds to go be home for however many days, whatever the case may be. All of that, though, falls under the same umbrella that SED is concerned about.
If SED sets guidelines, we have to stay within those guidelines. We can't say, like, let's say someone does something that we think is very not appropriate. We can't suspend them for whatever period SED is saying the suspension.
It's a good question. So what we have to guide, I'll say us, but really it's you, the board. You have the commissioner's regulations that speaks to and establishes what needs to be in a code of conduct. Your code of conduct has been around for 25 years at least. It's reviewed every year by the board. It's supposed to reflect the values of your community within the confines of the regulations that establish those codes of conduct. As it relates to what's an appropriate consequence for a given situation, you will be somewhat limited. The only time the law ever speaks to a specific time frame is firearms in a school. That's a minimum of 1 year. That's the only time that you'll actually see a time frame established. Everything else will be governed by your code of conduct, your community, but more importantly, the Commissioner of Education has the ability to review these types of consequences that are imposed. In the old days, I would get calls from school district superintendents, building principals to say, this is the conduct, what would the commissioner support as far as the consequence is concerned? Under the same fact patterns, over the course of the last 15 years, what I have been able to advise clients has significantly decreased. I have found, our office has found that the commissioner, not surprisingly based on what we just saw in those last 3 slides, has a limited appetite for long-term suspensions or removals or exclusions, except in the most serious situations, generally involving violence or serious threats or credible threats of violence, meaning law enforcement's involved, or weapons are in school primarily. So with that, my advice to clients has been changed over the years, and these exclusionary practices have been meaningfully reduced. And that's all subject to where the commissioner would come down if it were to reach her office, and the consequence there is that she would dismiss those decisions of the board or the superintendent as being arbitrary. Any other questions before we move on to the due process component? If we could, Superintendent. Under Education Law 3214, there are due process protections for every student in a school prior to being excluded. In this case, we'll talk about suspensions. Your code of conduct will speak to removal from classrooms. The educational law speaks to removal from classrooms. In-school suspension is different. These are out-of-school exclusions or suspensions. Before this can happen at the building level, let me take a step back. The only person who can suspend a student or exclude a student from school is in the first instance, is the building leader, your building principal. An assistant principal can't do it. A dean of students can't do it. It has to be the building principal. They rely on your code of conduct. Again, that's where the board intersects with student discipline. Every year you're looking at that code of conduct. A student engages in behavior that the principal believes is contrary or in violation of your code of conduct. He or she can then determine what's an appropriate consequence. Your code, I believe, has a bit of a menu. Depending on the specific facts, it gives the principal some discretion, because not every case is identical. It's almost impossible to have those come up identical. So it gives some discretion there, but within parameters established by the board. But if the principal determines that disciplinary consequences are appropriate, that would include the exclusion from school, they have to engage in these bulleted steps, each of which is to protect the student and their rights. It makes sense if you think about it. In most general terms, it's notice of what happened, it's an opportunity to be heard, and then it's a right to appeal. That's pretty much minimum due process. So I know that your district, because I've seen your letters before, comply with this obligation under the education law. It notifies a parent of the intention to remove a student from their education. It will inform them of the reasons why. In most instances, it invites them for the opportunity to come in before the implementation of that exclusion so that they can be heard, so they can question witnesses and better understand what's happened. They might come in and tell us, Ryan wasn't in school that day, you have the wrong student. That's great for us to know before we impose any sort of sanction, and thank you for that, and that's the process working. We might better explain to a parent that this is what happened, here's why we're taking this position. And they might better understand that and be satisfied with that. What's important is that they actually have the notice. There are steps that have to be taken before a student could be suspended, that the parent receive written notice of the concerns and written notice of that invitation to come in and speak to the building leader. Again, I've seen your letters comply with that. You've been very good in making sure the parents get those before the suspension is implemented. There's an exception to that rule. If your building leader believes that that student poses a threat, they're able to suspend first. The letter goes out second, and then that meeting occurs in prompt fashion. So there are exceptions to that rule about notice and then suspension, and it will turn on the nature of the behavior and do we believe there's a continuing threat or danger. You want to jump to the next one for me? Again, this is an informal conference opportunity. As a parent, you might want to hear exactly what happened. You might want to be able to tell your child's side of the story or allow the child to tell their side of the story. And that's what this informal conference conversation is. This is, as it relates to what I'll call short-term suspensions, although I recognize if you're a parent, any period of suspension feels like a long time. But a short-term suspension under law is 5 days or less. And you have that obligation, and the parent has that opportunity to have this conversation. This is not a lawyer meeting. I don't ever attend those. Students don't have a right to bring their lawyer to that. It really is an informal conversation, opportunity to understand what happened and the basis for that determination by the building leader. And then there's the issue of a right to appeal. So what you'll hear throughout this conversation when it comes to due process is that right to be heard, that right to be understand what the allegations are, and then appeal rights, because there are several rights of appeal. In Voorheesville, you'll see here this language says that you can either, again, speaking to short-term suspensions, you can either go to the superintendent on appeal or you can go right to the commissioner of education. Many districts incorporate into their code of conduct the appeal to the superintendent before it goes to the commissioner. If there is a basis to overturn the decision of the building leader, there's a value to having it done in district with the superintendent. In Voorheesville, that is what you have chosen as a board. If my student is suspended tomorrow for 3 days and I'm not happy about that, I would have the right to appeal to the superintendent of schools to be heard on that issue. In other districts where that is not available to me, I have to commence administrative litigation before the Commissioner of Education. So you folks here, though, have chosen as a board to have the superintendent be the basis of appeal in the first instance for a short-term suspension. And that language is set forth in your letters that you use. Any questions about the short-term? Okay. Long-term suspensions. If the behavior that's a concern is something that administration believes warrants more than 5 days, they can't just go through that same process that we just described, because the way the law views this, appropriately so, is this is a more serious impact on the student, which requires additional process. So if you want to advance for me, Superintendent. Anything more than 5 days would require what we refer to as a superintendent's hearing. Again, under Educational Law 3214, it's an administrative proceeding. It takes place right here in the district. Once again, it's predicated on notice, written notice to the family that talks about all the various rights. At this stage, certainly you have the right to be represented by counsel at any hearing. The district bears the burden. For our clients, it's not uncommon at all for us to be, in some cases, the hearing officer, we'll talk about that, or I will be the one putting on the proof. I have to prove in that instance, or your building leader has to prove in any hearing by substantial evidence, preponderance of evidence, that what the district says happened. So more likely than not, or that there's some substantial proof of that. So we have to tell the parents that we bear the burden. They don't have to say anything. The student doesn't have to say anything. The district would have to put on evidence, be it testimony or video or written documentary evidence, any credible evidence. But parents would also have that right. The hearing officer could subpoena witnesses. Parents would have the right to bring their own evidence and proof. I don't want to speak in terms of criminality, but it's like a little trial. It's an administrative proceeding, but there's a hearing officer who presides. The strict rules of evidence don't apply, so things like hearsay and whatnot could come into it. if it's relevant and credible. But the purpose of this is it's twofold. It's a two-stage process. The first stage is, did this happen, as alleged in the correspondence? And the second stage is, if it did happen, what's an appropriate consequence in accordance with your code of conduct? If you could advance for me, please. So these are our phases. I don't necessarily like using the expressions of guilt and penalty. It seems too much like something under the penal law for my liking. So I would do a fact-finding phase and then a consequence phase, but that is what the law speaks to, is guilt and penalty. There's procedural safeguards throughout this process. Everything has to be recorded verbatim, so there's an audio record of everything that occurs in any hearing held before a hearing officer or the superintendent. Other procedural safeguards include no reference or reliance on the student's prior discipline, if any, unless or until they're found to have engaged in the actions. That's because we don't judge whether someone's guilty or not based on what they've done in the past. So that's important to protect a student's rights. And then there's a written determination, which is also important. That creates the record. It's your charge letter, a hearing officer appointment letter, if that's the case. And in that regard, the superintendent has the ability to either preside themselves or to appoint a designee. So it's not uncommon for me to serve as the hearing officer to make the recommendation to the superintendent, who will ultimately be the decider of whether they agree or not with whatever the recommendation may be. But that would be part of the record, the audio recording, any evidence that was submitted, and then the determination. So the parents would receive a determination letter that would spell out the findings. And then if the parent is unhappy, if the finding was such that the student is subject to additional consequences and they're not happy, parents can appeal that determination to you, the board. So in addition to your review of the code of conduct, which is a policy, it's on your website, I saw it an hour ago, 2 hours ago, you also are an appeal authority. So this really would be the first time you, the board, would be cognizant of, involved with, or aware of a student disciplinary matter in any specific manner. On an appeal, it is my recommendation that you give the parents an opportunity to submit a written position to you, as opposed to having a parent come in to speak to you the way I'm speaking to you right now. I think having a clean record, also giving parents the opportunity to collect their thoughts and state their position, is beneficial for everyone. And then in any appeal process or hearing, you as a board, outside of the public session, because this is a quasi-judicial proceeding, would listen to that audio. The board has, if it's a 3-hour hearing, down below, you have to listen to a 3-hour audio recording. But you would hear everything that occurred in that room, you would review all the evidence, and then you would act as an appeal authority to make a determination of whether that determination at the superintendent level is supported by substantial evidence down below. If you could. So that is your role. There's 2 correspondences involved in that. The first is to invite the parent to submit something in writing, and then the second is your determination as a board. And then from there, if the parent is unhappy with, assuming for this example that you upheld the consequence and the parent's unhappy, within 30 days they can appeal to the Commissioner of Education. And the commissioner would review that appeal to determine whether or not your board decision was rational or was it arbitrary. They'll look to your code of conduct. This is where we talk about the consequences and what I said earlier, which is the commissioner is sensitive to duration and length. So you as a board might feel that a particular length was appropriate, and the commissioner may say that's not where New York State is any longer. And that's the purpose of that level of appeal. If the commissioner were satisfied with the board's conclusions and the parent was unhappy, they could take what is called an Article 78 petition against that decision and challenge the Commissioner of Education's review of that appeal. So parents have many layers of review and many protections to make sure that school districts get it right. Just quickly, as it relates to exclusion, students of a compulsory age or classified students have a right to continued education, even if they're excluded from school. There's, we call it tutoring, but it's continued education. It's been increased from where it once was. It's now 15 hours a week. You can advance back. it's a requirement. It's something that your district has historically done always, even when 15 hours wasn't required. I know that you've been open to providing additional time, but any student who's excluded from school is entitled to 3 hours a day, 15 hours per week of this instruction. That's lately, in many districts, it's virtual since COVID. Historically, it used to be at the library or at the high school or wherever the case may be, but that is an obligation, and those requirements were just increased last summer, maybe 2 summers ago at this point. So now it's 15 hours. I don't want to get too in the weeds with regard to classified students, but what the board needs to understand is that there are, in addition to all the procedural safeguards that we just discussed for all students, students who are classified as students with a disability, whether it be through the IDEA or 504 of the Rehabilitation Act, have additional procedural safeguards. Makes perfect sense when you look at what they are, but in its most basic terms, and we can certainly get much more nuanced with this, but maybe not tonight because you have places to be, I'm sure. What the law speaks to is if a student who is classified as having a disability is removed from their educational placement in what would be more than 10 times. So that might be a long-term, anticipated long-term suspension that would take them past 10, or it might be 10 individual removals or disciplinary changes in placement. But if you get to that number, before that student could be removed from their educational placement again, irrespective of what the allegations are against them, there needs to be a manifestation determination review, which is a specialized team who know the student, who outside of the context of the disciplinary proceeding, it occurs at the same time, and I'll talk about the process, but with that team, there's an analysis to determine whether there is a nexus between the student's disability and the behavior giving rise to the disciplinary proceeding. The thinking there is, with a few exceptions we'll talk about, we don't discipline kids because of their disability. So if there is a connection between their disability and the behavior, that's an issue for the Committee on Special Education. That child would not benefit from being excluded from their instruction. That's if there is a connection that's found. If no connection is found, then we would proceed as we would with any other student going through that process we talked about in the first part of the conversation, which would be the, at that point, the consequence phase. So just so you can put this in a place and a time with a classified student, we talked about with a general education student, you had 2 phases, which is, again, the guilt or innocence and the consequence. In the situation here, it would be guilt or innocence. If there is a finding that the behavior occurred, then we would go to the manifestation determination review. And if there is no manifestation found, we would discuss consequences. If manifestation is found, it becomes a CSE matter and not a disciplinary matter, with 3 exceptions. We're getting there. The 3 exceptions being, even if a manifestation is found, if the behavior involved a serious bodily injury, drugs, or a weapon, then there's also the opportunity for a district to impose consequences where they otherwise would not be allowed to do so. So that's it's a specialized process. It's heightened due process and protections, and in its context, and as you see it play out, it makes perfect sense. Again, because we don't discipline children based on their disabilities. Could I see what the next slide is? This goes a little bit into the weeds about manifestation. It's available to you. I'll leave the slideshow with you all if you want to read it. I'm happy to answer any questions that the board might have afterwards. But for tonight's purposes, I think I'm just going to give a general overview, which this might be a little too in the weeds, so to speak. This is our exceptions we just talked about. Those are our 3. And then we can stop there. But these are just common mistakes, and not surprisingly, they're all primarily procedural because we have to respect students' procedural rights and protections. That is a brief overview of student discipline. Going back to where we started, which is the landscape is changing significantly. You as a board will always have oversight of your code of conduct, but I can tell you, if I were to forecast the future, I mentioned, Superintendent, I mentioned that a decision just came out where the Commissioner of Education said that under no circumstances could a pre-K student ever be suspended or excluded. I would anticipate in the future that will be expanded to include other elementary age students. I imagine in the future that the law will be modified to discuss that progressive approach with restorative aspects, and exclusionary consequences will be limited to very specific circumstances, probably along the lines of weapons, drugs, alcohol, or serious bodily injury. So you as a board should anticipate having a limited ability in the future to exclude students from instruction. And that's can be challenging, but that will be the reality in New York State if I had to place a bet on that. What other questions might you have for me while we're together? Yeah, please.
Towards the end of the presentation, in the part that you didn't cover, which is totally fine.
I can certainly go through whatever you like.
It just basically says you can go with like creative forms of discipline. And I know that restorative justice has had a lot of time in the spotlight, but I don't know that there's any research that's proven its efficacy or its effectiveness. And I'm curious as to whether or not the commissioner has been doing, or not personally, but has research demonstrating its effectiveness and the best ways to,
So I can certainly tell you two things. One is that the commissioner has devoted a significant amount of time in looking at exclusionary practices and forming an opinion on that, which is a very dim view. I can only surmise, based on correspondence and guidance coming out of SED, that there is constant work being done on the restorative aspect of this. I know that it's being pushed tremendously by SED. I don't know, and I can't speak to tonight, what type of data they've collected and what type of results they've come up with from that data. But I do know that it's been a priority for at least half a decade with SED. To the creative solution part, I'll just say that there have been many hearings where I wish nothing more than the superintendent could impose, meetings at Spark for addiction recovery or something like that for a student, and they're not able to do that. That might benefit the student much more than being home on the Xbox during a period of suspension, but those are the types of things that without parental consent and buy-in, we as a district just can't do. I hope you feel educated on that topic. I'm happy to come back. You have access to that PowerPoint, which goes into a much greater depth, but I appreciate coming out and having that opportunity. Okay? Thank you very much. I'm happy to come back and talk about anything you want to hear about. Thank you.
thank you, have a great day.
You too.
Joey's probably still recovering from the game, so congrats on that, and we'll move straight to item 3.3, the superintendent's report.
Okay. So I want to give an update first on the capital project. As you may have seen, we've been making a ton of progress in the building. The scaffolding is now all fully up, so there's the whole scope of it. Someone said it was called Buckingham Palace the other day. I giggled and I asked him, he was walking his dog, I said, could I please steal that? So, but that is up, so you should see paneling within it shortly. So we are still on track. We have hopefully move in by April, May, which is pretty exciting. Given that part of it, we are now moving to going on to bid for the elementary school. So our bid is going to go out January 23rd. We'll start seeing that in the newspaper shortly. And then February 13th is the awarding of the bid. So that way by March board meeting, you'll have the votes to be able to award the bid contracts. And then the goal is by June, we're able to really start understanding the scope of the project and starting. So that's kind of where we are, the whole streamline. This is getting done. Next is going to be the elementary school. It's going to be a full court press at the elementary school until December, January of next year. And then we should be seeing it being done at that point where we can then start looking at other projects We are currently looking at other projects now. As you know, we do a $100,000 project yearly. It's a capital outlay project. We get funds back on that, so it's sustainable. So we look at those yearly as well. We just closed out the vestibule in the high school, because I think sometimes people forget some of the things that are happening. So that middle school vestibule was done last year, the high school vestibule was finished this year, completely done, and I believe closed out as of today. He said, yep, so that's now closed out. So we're now moving forward with a lot of different projects. Just find an update on those other things. The one last thing I want to talk about quickly, it just came out, and I posted it. The New York State Science exams for grade 5 and 8, we released the scores. It's posted there, over 580 school districts, we were in the top 100. Our staff worked really diligently with our students. The outcome of that curriculum, the change management, I think we just did a great job. And I just want to kind of tout it a little bit that they did awesome. Our scores showed it, so that's all to our staff. Really, that's all I have.
All right, with that, we'll move to the budget presentation.
Okay. Lisa's going to come up and we're going to kind of do this together. So,
This is also attached to.
yep. All right. So the purpose of this is to really just get us started on all the things that kind of go into a budget, some of the things that kind of factor into the budget as we start. Because we're still in January, it's pretty early. There's still a lot of things going on. But one of the things that we want to talk about, and I kind of want to show them to you, and you know them already, is that the things that guide us is the Voorheesville vision statement. Our mission statement. And I'm just reading because I think it's powerful, and the board worked really diligently on this. The school district is to provide all students a strong foundation of knowledge and experiences in a safe, supportive environment to prepare them to be productive members of a global society and to value lifelong learning. And then we have our goal statements. One focuses on student achievement. Again, we know these, I'm not going to read them to all of you. If you want to restate them. Staffing, financial responsibility, communication, and safe and supportive learning. I think it's important because what I want to talk about with these is these conversations aren't just statements, these vision things aren't just there and sit on a shelf. These are what are used to guide every decision that's made in the district. We look back and say, can we go and say this fits into that goal? Can we say this would build into that goal? So every time we have a conversation regarding budget, a lot of our decision makings, our curriculum, our planning for the future, we try to fit into those quadrants, those goals. Is this doing this? Our financial responsibility. For example, as we did this year vestibule, we used smart funds money because we realized we had that fund. We used capital project money. We didn't want to go out and put another tax burden on the community. Were we fiscally responsible? Are we utilizing grants to the best of our ability? Are we making sure that we're using Lisa's schedule N? Is that correct?
Correct.
Schedule N and all these different things to maximize what we do. So, for example, schedule N deals with safety. So when we're talking about door hardware, now let's upgrade our door hardware, costs $40,000. Can we get that through schedule N and get reimbursement for it? So when we're having these conversations about safety, we're also looking at financial responsibility and being good fiscal stewards of our community's taxpayer dollars, because we are primarily taxpayer funded. I know I am as well as all of you are. And we want to make sure that we're doing our best with the funds that we've done every year. We don't have unlimited funds. They are what they are, and they don't increase exponentially. So we know that we have to really use these goals to get self guidance. Any questions?
So what you won't see tonight are numbers. It's too early to provide you numbers. And based on my experience, sometimes when you present a number, it gets fixated on. And it comes up meeting after meeting. So right now, we're just going to talk in broad terms as to where we are in the budget process, what we're working on, what are our expectations, and by February, we will have your preliminary budget. So although it says January 31st, she releases her executive budget proposal numbers. I know January 14th at 1 p.m., she will be presenting the state of the state, and I will be listening to that attentively. February 3rd, our next board meeting, will have a draft budget proposal presented to you. February 24th, Board of Education candidate petitions are due March 1st, submission of the tax levy. And I've already started working on that. And we'll see that on another slide. Next, please.
So, as we're talking about those things, we also want to talk about the planning that goes into it. We start future planning our budgets actually a year in advance. We start looking at curriculum, planning, and personnel. Then come November, December, the building administrators, department chairs, department supervisors, supervisors of departments itself, like transportation, record facilities, food services, technology. They all start working on the budget proposals. They reevaluate what they currently spend, see if that is the fiduciary responsibility, and they're maxing out what they currently have, and then understanding what they could be looking for in the future to help their needs. They start meeting with Lisa and myself. We started in December, right? Lisa started in December, and we're still continuing to meet with building administrators throughout the month of January to finalize their budgetary requests and understanding where our outcomes are so that we can understand when I put a budget together exactly what we feel is these topic ranges from facility projects, safety initiatives, mental health supports, curriculum supports, personnel, you name it. It kind of looks at all aspects of the learning of the district for us to be able to create some budget. When I create that budget and put it into it, this is not my own responsibility. I'm not saying this is what we're doing and I make it up out of thin air. It's coming from all the viewpoints within the district, and I'm taking those viewpoints, working out with Lisa, and then really understanding what we can put into a budget or not based off of the board goals that we have envisioned in this district. Well, those are board goals. Rachel said district goals, so I just want to clarify the goals. But that's how basically that budget will work, and that's the process that we're currently. Any questions on that?
Okay. So you can expect to see a vehicle proposition for the May 20th vote. We have reviewed the bus replacement plan, and we need to update it a little. We need to look at how we are using our vehicles, and I'm embracing that project. So we'll be looking at 2 72-passenger diesel buses and 1 large electric school bus. The diesel buses, they're aided over 5 years, so even if you pay cash, you're aided over 5 years. Our district, Voorheesville, bonds, does a statutory installment bond for 5 years, so your aid matches your bond payment. Electric buses are currently aided over 8 years. However, you'll see in the further presentation that there is a recommended change on that 8 years. Okay, next, please.
And as of today, we did submit for a grant. We can offset the cost. It's $160,000. Again, we are a low-income district. We don't always get first dibs on all these things based off of our needs. But I am hopefully optimistic that we'll get something through that to help do that. So we are putting in to be able to be based off of these buses to make it work out.
Could you refresh our, or at least my recollection, anyone else who might be useful for, what the requirement is for the school buses, or for the electric school buses, in terms of, I think that by X year,
2027.
purchase.
By 2027, we are only supposed to, I believe it's still 2027, they haven't changed it.
Yeah, I think it is.
And again, I don't have it in front of me, so I could be off by a year, but don't quote me. 2027, we have to only purchase zero-emission school buses, which right now are only electric. We don't include propane or any other bus in that. And then by 2031 or 32, put in the 2030s, I don't remember off the top of my head, you're supposed to be fully switched over, maybe 2035, fully switched over, have your fleet completely changed over. So they're not giving a huge window to that, but we have to start thinking about that in the long term. There are incentives that are out there, again, that depend on the district and need and how many incentives you can get. And also infrastructure, right? Like,
Yes.
not all school districts have the infrastructure that we have. We were right
We're ahead of the curve.
To be able to develop infrastructure that can future-proof the district for this. And that's what we're doing. Again, I want to clarify one quick thing, and this is important, talking back to our financial responsibility, is when we put the bus garage in place, we have conduits run throughout the whole area, but we are not running the electric, we are not running the systems. We will run those as we purchase the buses. Technology changes, things change over time. So we put in the groundwork, not putting everything out at once. So it's a very scattered approach. Buy a bus, add the electric, they use that as an example.
The foresight is there, and that's great, because, and you're ahead of the curve, because most districts are trying to catch up. So that's great for a small district. You're doing well. Next, please. Okay, just brief review of the tax cap. I can't believe it's been since 2011. Wow, 14 years. Amazing. So, as you know, I'm not going to go through the details, as us nerds, accounting nerds, love, but it has many, many calculations, okay? What do we know now? The allowable levy growth factor, I haven't heard what it's going to be. That's the 2%, okay? Last year it was 2%. I'm not sure what the number will be. It's based on the CPI for the previous year. The second number that we do know is the tax base growth factor. And if you know what this is, I apologize, but I'm going to educate you. It looks at Voorheesville's school district and the property, and it comes up with a determination, a calculation as to what is the rate of growth in Voorheesville. And right now, as of December 31st, that rate of growth is 1.0175, and that's a tremendous rate of growth. You know, you live in this community, your community is growing. Many rural districts do not see that rate of growth. That will only benefit the calculation. Okay? Next. That's briefly. So as soon I have started working on the tax cap, I'm gathering the information. As soon as I know more, I'll have that baby calculated. Okay. Foundation aid history. And I'm going to bore you to tears, but it's very important that you understand where we started and where we may end up. So back in 2007, I remember this, they consolidated a bunch of aid categories and created this foundation aid. It was to provide a sound basic education. It started at $13.6 billion and it's up to $24.9 billion in 24-25. And it represents just a little over 70% of the general support state aid for school districts. Okay. So, you know, $24 billion is a big chunk out of the state budget. And the governor is a little hesitant to provide additional funds past that $24 billion. So they confirmed the Rockefeller Institute. They asked for input. They've done many, many overviews and oversights of the formula, because it's just not an easy formula like the tax cap is 7 steps. This is convoluted. So, in fall of 2024, the Rockefeller Institute recommends changes in foundation aid. Whether these changes happen, that will be up to Albany. But right now, this is the recommendation. Eliminate the guaranteed minimum payment of $500 per student. Reduce the use of Save Harmless. And researchers found a clear relationship between spending and student performance on New York State assessments and the Regents test. Okay?
One of the important points of this is, if you remember last year, after the governor put up the budget and everything changed, there was the concerns that came up, right? How much will school districts lose? Then we were hearing about rural school districts, $1 million in the hole, $1.5 million. We don't know what the landscape's going to be out of this, but we know that at least what the recommendations are, we can have a basic understanding of what the landscape is going to look like, what happens.
Is there any understanding of how the governor reviews the Rockefeller Institute's recommendations?
I haven't heard anything yet, but I'm sure I will on January 14th. I said something about zero-emission buses, the electric buses. The Institute recommends they fully underwrite the cost of the mandated transition to zero-emission buses. And that's something you don't hear a lot anymore about unfunded mandates. That used to be a hot topic about 15, 20 years ago, but that's kind of gone by the wayside. Using rolling averages and multi-year phase-ins to improve predictability and reduce volatility. Amen. Some of the averages and years that they look back might be 10 years old. As far as, I haven't looked recently, but they were not using current census data. The census data they were utilizing in state aid formulas was from 2010. Let's see, reduce allocations to school districts with large reserves. Require districts retaining more than 10% of their budget as a year-end balance to apply the excess as an offset to save harmless allocations. I asked the superintendent to please look at our fund balance policy and our reserve policy and just make sure that we are following our policies and they are up to date. I have a strong suspicion that this last bullet will come to fruition. I've heard many discussions at my level, the business officials level, that she's looking at fund balances. So we need to be prepared. Let's see, reductions of state harmless. Student performance measures replace the regions with a 3-year average district-wide pass rate on New York State ELA and math exams in 3 to 8. This one was surprising. Create separate aid categories to address needs involving students with disabilities and small enrollments and enrollment growth. Well, we already have aid categories that address student with disabilities needs, so maybe they're talking about expanding that. So that will be interesting. Sorry. Last, just to remind you that our budget calendar was presented on December 9th and approved, and we've been talking about it. Here we are doing a budget planning presentation. The 15th, the administration and supervisors, directors will have their finalized budgets, and I'll be crunching numbers late into the night. My husband bought me a banker's lamp, so I'll be utilizing that. February 3rd, that will be an important meeting. You will have your draft budget, and you will also have a long-range financial plan that will be presented by the fiscal advisors, and that will give you a really clear picture of what the district's fund balance looks like and projected expenditures 3 to 5 years. It is eye-opening. It's not to be scary, but it's eye-opening. And it's something that you should use as a tool when you develop your future budgets. Again, February 24th, your board candidate positions are due. I will submit the report card. You're going to have a meeting. Unfortunately, I won't be here on March 3rd. My son is getting married. April 7th, we will have a final presentation of the budget. If need be, we can go further. Next one, please. Further into April 23rd. And April 25th is the last day for the board to adopt the budget. So April sounds like far away, but it's not. One thing that I would like you all to do, a little homework assignment, is School Board Association put out their position statements for 2025. This is what was presented, or this is what they're going to present as far as the executive budget policy recommendations. Very interesting. So I just ask that you go through it and think about how it will impact Voorheesville. Thank you. Thank you.
With that, we'll move to item 4.1, minutes of the regular meeting. in favor? Aye. Okay, the audit committee is set to potentially meet in February. Okay, so that's set there. Search committee, January 21st. Saturday. Facility, next Wednesday, right? Then policy, soon to meet.
Yes, we're meeting on Thursday morning. We ended up meeting 2 times before the last meeting and this past month. Just to keep you aware. So there is one update on the agenda 7.3. Yes, all we're doing here is updating cross references to policies that we approved amendments to in our December 20th. It's just a very simple update for this one.
With that, we have donations that have been offered to the district. Before we say thank you, would you like to move it? Second? Well, let's, wait, can we, you said the ones on the district together? Sure. Second?
Second.
All in favor? Aye. And very grateful to Andrew Phelps for their help. Appreciation to that. So we can paperwork. With that, we have those cross references to look at, 7.3. Anyone like to move that? Or second? Second. All in favor? This brings us to the opportunity for the public to be heard at the end of the meeting. Any member of the public who would like to be heard, the podium is available. Be ready to come forward.
Good evening, how are you? My name is Michael Wilson. I've been associated with Voorheesville for over 20 years. I've been living here for 4. My wife graduated from this school. It's my wife sitting right there. She graduated from the middle school, grade school, high school, all that good stuff. I'm not the most educated man. I ain't stupid either. I sat and I listened to a lot of what was said here today, and you were saying a lot of things. I'm not gonna lie to you. I have no clue. That guy that was standing here, he had a lot of words. I work for CDTA. I'm a training coordinator. I'm just Michael. Okay. The biggest concern that I have here, in case you haven't been paying attention, I'm a man of color. I know it's hard to see that, but I am. My son goes to this school. My son is an awesome young man, okay? My son got the Principal Excellence Award this year. It made my day. He's on an honor roll. He plays for Modified. He plays for CYO. I'm his coach on CYO. We've got our roots here in Voorheesville, and I have no intentions on going anywhere. I'm not going to get into names, obviously, because I can't do that. But I was listening a lot to well, we have to protect the children. I got that. I have children, okay? But my issue is at what point are we going to put the other children in danger because of one child? I don't want anything to happen here in Voorheesville, but let's keep it 100, okay? Let's keep it real. We've already had, in 2025, we had over 81 mass shootings. How many school events have we had where kids have died? Let that marinate for a minute. The situation that my son had to deal with, being called out of his name. Other situations going on where the child that I'm talking about, and it's well known, it's not no secret, I'm not gonna say names standing here now, but this is not the first time I've had to hear this child's name. I understand we're supposed to protect the children and their right to have an education. I got that. But what am I supposed to do if there's no metal detectors in this school right now that I know of? What happens if this young man comes in and stabs my son in the back? Or goes around? By the time it's corrected, my son's dead. I pray to God that does not happen. But at the end of the day, if this child has emotion, I'm not a psychologist. I don't play one on TV. So I'm not going to sit here and try and get into anybody's psyche on why this child is having the issues that he's having. And I'm sorry that he's having these issues. I'm sorry that he's having these issues. But at the end of the day, I'm going to be real with you. I could care less about that. I want to know if my son is going to be safe when he comes into this Voorheesville school, period. That's the only thing I care about. I want my son to get a good education. I want my son to be safe. And if one child out of however many's in that class is having an issue, then I think you need to deal with that child. That's my opinion. It may not agree with everybody else in here. I could care less. I'm not here to be friends. I'm here to make sure my son is safe. There's not a lot of kids in here of color. It is what it is. I didn't make it that way. It is what it is. I still love this community, and I'm not going anywhere. And I want my son to be safe when he's here. But it's not just of color. The particular young man that I'm talking about is talking about Jews, writing stuff on bathroom walls. Go ahead. Okay. But see, I understand why.
I very much hear you, but we're also trying, I hate to cut someone off, but we do try to keep things to 3 minutes. And
You should keep it what?
to 3 minutes.
I didn't know that.
It's okay.
I was going to keep going until you told me to stop.
I think we're all happy to hear from anyone who has something they want to say. Absolutely. But we also want to make sure that we don't go to, for instance, specificity so that people don't.
I understand. Okay, I'll try my hardest. But the problem that I have is because I've always, since I've been on this planet, I speak from my heart. And it's very hard for me. I don't sugarcoat this. So, my son means the world to me. He's the most important human on this planet. And if he's not safe, I'm speaking up about it. Okay, so I understand about getting too specific. I got that. But at the end of the day, the specifics don't matter to me. I want to know if my son's going to get stabbed in the back or if something's going to happen to my child. And that may not be a concern for you, but damn, it's a concern for me. Okay, so I don't know what more to say because everybody, not everybody, a lot of times I hear these kind of situations, people want to sugarcoat things, people want to, sweep it under the rug. I don't sweep nothing under the rug.
Mr. McCree would like to follow up, please.
Yes.
Yeah, can you wait for after the meeting?
Absolutely.
Conversation, thank you.
So I guess I'm done until the next person.
What?
No problem. I'm sitting here waiting for you. What's your name? Frank?
Frank.
It's Michael.
Sorry.
Frank. Reach in the
Yeah,
back.
Mr. I just heard Michael.
Wilson. Michael Wilson.
Wilson?
Yes.
Like the volleyball.
Say that again?
Like the volleyball, sorry. Yes, like the volleyball. Thank you. Okay. All right, excellent.
We're good?
Thank you. Yes, thank you.
Hello. My name is Stephanie Remmert, and I am also here with similar concerns. I do have a few questions after listening to Ryan that I just want to pose to the board. I don't know if maybe you know these answers. I'm not expecting you to answer them now, but I'd like them to be considered in the future, which is one, in terms of suspension, both short-term and long-term. Do non-school days count? For example, do vacation days count? So if a child is on suspension right before a holiday and then vacation happens, are you counting those dates? I'm seeing no's. Okay, just wanted to clarify that. And I'm also wondering,
So if you have a school day, it's the days in session when the child will be going to school. So if I was suspended on Monday, Tuesday, break is Wednesday, Thursday, Friday, it would be Monday, Tuesday. If it's a 5-day, it would be the next Monday, Tuesday, Wednesday. My next day back would be then Thursday. Snow days, I have to check regulations.
that's fine, that answers it. Thank you. Also, it occurs to me that I do have some questions about what is considered proof of violence. I'm not sure that's very clear. Maybe it is somewhere, but maybe just some clarity for the community for what constitutes as proof of violence. Is it overhearing a comment? Is it physical attacks? You know, what is the proof of violence? Similar to what Michael was saying, just if there's a verbal threat, is that proof enough? Or are you wanting it on video, via text? Like, what kind of concrete evidence do you need to show proof of violence? And this is just a general question. I'm not speaking to any incident. It's just a general question that occurred to me after listening to Ryan today. Another question I have for you, and I'm sure this may relate to some of the code of conduct that Ryan was talking about. It sounds like you may have some room for changing the code of conduct to enhance the discipline policies at Voorheesville, if that's something you're considering, or at least that's what I maybe took from what he was saying. Is there a certain number of suspensions that a child can have before they are removed from the district? I don't know if that's an answer you have now, but that did occur to me in hearing Ryan, is if a child was suspended, let's say 4 times in a year, is that grounds for removal in the future? Or what is the cap on that, or the scope of the suspension?
Expulsion, you can't remove a child from attending school, especially if they're compulsory age. They have a right to free and appropriate public education. And this is the law.
You're saying, let me just repeat back to clarify, you're saying that a child can only be suspended once in a calendar year?
No. They need to be suspended for a length of the calendar year.
Oh.
So let's say Frank McCree is suspended for 2 days.
Mm-hmm.
And then there's a superintendent hearing and Frank McCree is suspended for 10 days. The next time it comes, it's more of a succession. He gets 30 days. The next day, the superintendent says, I'm going to suspend you for 1 calendar year. That would be the maximum that you could suspend a child for, to 1 full calendar year.
But how many incidents can happen before a child is removed?
There is no, expulsion. There is no expulsion in New York State. You're compulsory age. You have to find an alternative.
Is that the New York State law, or is that?
That's New York State.
Okay. Thank you. Those are my suspension questions, and I just have one other comment and suggestion. I don't know if this is possible, but I think that there's lots of confusion about the incidents that are happening at school and how they're being dealt with. I think that there's a lot of rumors going around about, and I'm not going to say them because I don't know what's true and what's not, but it does question my ability to trust the school district and my son's safety at school, just because it's not clear what the discipline is. That's why I came here tonight, because I knew that it was on the agenda. I am here, I love this district, but I am challenged with trusting it, just based on what I'm hearing. I don't know what to believe, and I would really like a statement from the board, from the school district, of just, this incident happened, I understand you have to protect the child. If my child had something going on, I wouldn't want his name thrown out there. I totally get that. But I want to know, this incident happened at school, and this is how we dealt with it. Because otherwise, that's how you get nastiness and rumors starting. So I don't know if it's possible to do that, but I can tell you some of the things that I have heard are horrendous. And I don't know what's true and what's not true. So therefore, I don't trust the district. And I'm sorry to say that, but that's my truth. So take that with what you will, and I hope that there's some clarity in the future. Sorry, go ahead. My name is Stephanie Remmert. Remmert. That's okay. Thank you very much.
Thank you, Stephanie. Appreciate your Stephanie, if your student is in middle school, yes, middle school student?
Yes.
Ms. Olson, Ms. Brianna Olson will reach out to you.
Okay.
I'm going to have to reach out to you.
Thank you.
Thank you very much.
Thank you.
Anything else from the public? This is the second opportunity for the board to be heard. Does the board have anything that they would like to discuss or share this evening? Thank the people people who came forward to be heard, and also thank Ryan and Lisa for the presentations, and Frank, as always, thank you for your presentations, and wishing everyone a very happy New Year. We do want to note that our next board meeting is the day after Groundhog Day, which is the 3rd of February. With that, would anyone like to adjourn?
I would like to.
All in favor? Thank you all. Have a great night.